Thank you.
Oh, okay.
I always think I'm live before we do any of this stuff. Okay, good morning, everybody. Welcome back to Senate Economic Development, Housing and General Affairs. It is Tuesday, May 19th. Okay, we have a new draft of H772, our landlord tenant bill, in front of us. And we have two things we need to land. I think we're in pretty good shape on everything except David Weeks' concerns about the Good Samaritan piece and the disability rights.
I'm sorry to you that the governor vetoed this
Yes,
state.
I know. Which is hard.
It's like a headline.
Jay, I know. I heard that. Yeah. So they're taking it up. Okay, so an update on that. They're taking up in House Commerce today, and they're hoping to fix the provision that Jay wanted to talk, that Jay felt was unconstitutional.
Oh, so they wanted a fix.
They wanted the governor to be able to have it be advisory rather than that this committee would have the last say. So the governor vetoed it because Jay felt it was unconstitutional. That's my understanding. They're working on fixing that in Commerce. So Randy will be happy to hear that, as well as Harding. So that bill hopefully will make it back to us in time, or we can just concur with that. So Cameron, good morning.
Good morning.
So is there, before we turn to Chris Donnelly, because I think the disability piece is our biggest point we need to land. I think I'd love to. Is there something you'd like to say about this draft before we turn to Chris Donnelly?
Yep, we can walk through the changes. They're very quick to point out.
Quick.
That's helpful.
That would be great. And then I think we want to move to the disability discussion.
For the record, Cameron Wood, Office of Legislative Counsel. You have a draft 3.1. That should be posted. You have a physical copy. I've made the changes that you all discussed yesterday.
Great. Thank you.
In particular, changing affidavit to written statement in the two instances where it occurs. So the termination of the rental agreement has to be accompanied by a written statement there.
Do you want to do pre-editing or no? Just because and should be a.
Sure. Yes.
Okay.
Yes.
I didn't know if you wanted us to pick up on
No,
things or.
that's perfectly fine. Perfectly fine. So, and then, same here, written statement, line 19, on page 4, where the written statement has to be included with the complaint filed. Thank you.
Thank you.
And then in section 1A, regarding the bifurcation, I deleted the subdivisions B1, 2, and 3. So by deleting those, I've renumbered the remaining what was A 1, 2, 3, just be A's. So you still have page 3. So in the bifurcation section, right. The landlord may bifurcate if it's submitted as a written request, shall bifurcate if it includes a copy of a court order requiring the individual to leave the property. And then nothing requiring that you didn't have to submit documentation. And the other change is going to be down here at the deletion, so you're not going to see it, but it would be on the bottom of page 5. I removed the section related to the tenant's property that remains after a writ of possession has been served, to remove the changes there, so it would just no changes to the current statutory framework. Those are the changes that I've made in this draft.
Okay, good. And my understanding is that we are fine with the exception of better understanding the disability piece. And so for that, I'd like to turn to Chris Donnelly if we could. Cameron, do you mind moving back here and letting Chris testify?
Can we put the language up with Cameron and frame it up with Cameron as our attorney?
Yeah, but I think we have to be clear. I mean, my understanding is that actually the concern is landlord-tenant education. And so I think we can address that with some language that Cameron's been working on. but first, I'd just like to hear from Chris about some of the challenges that
And everyone got big Hartman's.
I haven't seen
email.
Big's thing. But I think there's a misunderstanding about how well.
You didn't read big Hartman's.
I didn't have time. I spent all day on legislative stuff, and in the evening, I didn't have a chance to go back online. Sorry. There we are. This is very last minute, and I just am wanting to make sure that we can get this, the disability.
Madam Chair, this is not last minute.
It is last minute.
And
We
this
haven't-
was the last piece of what we were
So
going to
what does
discuss
Big
today to vote this out.
Right.
So I think we should seek to get Big online or present for this conversation. I think we should have attorneys discussing this
Right, the attorney
because this isn't just an education.
I think it is mostly an education because actually, my understanding from our attorney is the disability committee is the rights that are embedded in statute for the disabled community in our landlord tenant law are substantial. The landlords may not.
Big said that it was in fair housing law, but not in landlord tenant law. And I believe Big is an attorney and does our fair housing enforcement.
Right.
So I think it would have been important to read that
Cameron.
this discussion today.
Cameron, can you?
I haven't even big Hartman.
Yeah, I don't.
Did they come yesterday?
I thought Big sent it to the whole committee.
She may not. So, Cameron,
Yes.
how the interplay of fair housing, can you do?
It just got sent to me in the chair, so I'll forward it to the rest of the committee.
Give me 1 second.
Do you want Letchy now?
And Kara, could you include Kara in that?
99%.
I'm just not gonna be rushed into consequential discussions about landlord tenant law. If you're telling me you didn't have time to read what the
I
Human
didn't- I
Rights
didn't know you
Commission,
did
I
that.
said, yeah, correct.
Sure,
Sent to
I'm
us.
sorry. There we are. Can't win it all. And we also have lives that have to be led. And sorry, we all were doing other things last night. So did you send it to Kara? I'd love to have it printed out.
I'll forward it to her.
Right. Okay. So the interplay of fair housing and landlord tenant law, I assume is. Yeah, can you speak to us about this?
Sure, I can speak to you a little bit about it. So I was just going to comment first. We're in Title IX, and Chapter 137 is the chapter that governs residential rental agreements. That's the one that we've been discussing primarily. This is the chapter that governs the relationship between landlord and tenant. And then under it is Chapter 139, which is the chapter that governs prohibitions on discrimination, public accommodation, and that includes discrimination in the rental and sale of real estate.
So here's
housing. And so when you look at 139, here are the sections. So you have the protections in regards to public accommodations, and then you have certain protections for housing, so listed unfair housing practices. So this is going to apply to not only the sale of dwellings, but also rental dwellings as well. And it has a list of prohibitions in the unfair housing practices section. So this is where you have all of the language that makes it illegal to discriminate against individuals by refusing to negotiate or rent to them, by discriminating or harassing them in the terms, conditions, privileges, or protections. And in all of these instances, there are many of the 12 listed prohibitions in this section. They all include protections for individuals who have a disability. I think relevant for your discussion here is it is unlawful for an individual to refuse to make a reasonable accommodation in rules, policies, practices, or services when such accommodation may be necessary to afford a person with a disability equal opportunity to use and enjoy a dwelling unit. It is also unlawful to discriminate against an individual because the person relies on aids such as attendants, specially trained animals, wheelchairs, etc. Here is where
So it doesn't discriminate in the sale or rental. So to me, that would imply we're talking about
initiation
initiation.
consideration. Right, but this is the section that allows an owner shall permit at the expense of the individual reasonable modification. So this is what we talked about when we initially began this conversation,
Right.
a few sessions ago. You are required to allow reasonable modifications. It has to be or can be at the expense of the person. It is unlawful to restrict
Right.
reasonable modifications.
So often when
You
we're,
also have to allow for a reasonable accommodation request to be submitted. If you terminate a rental agreement because someone is disabled, or you terminate a rental agreement because someone has requested a reasonable accommodation, that is illegal.
Right.
It is illegal under the current law right here in this section.
refusing an accommodation is different than evicting them.
So as I've said a few times, right, this is unlawful to discriminate against someone, to terminate because they are disabled. If what you're talking about is where someone is engaging in some sort of activity that is manifesting itself because of a disability, and that activity is breaching the terms of the rental agreement or is leading to the individual not complying with their obligations. So they damage the dwelling unit or they're disrupting other individuals' peaceful enjoyment of the property. I imagine those are probably two of the instances where something may manifest itself that could lead to a termination. You can terminate the rental agreement and evict or eject the person based on that activity.
So I think what commonly happens in these situations is that the reasonable accommodation, especially if we're talking about a larger housing provider, is to try and give them a dwelling unit where they're not disturbing the peace of others. So this is where fair housing law and landlord tenant law need to be complementary and need to fit together. And so I feel very strongly that to make fair housing law, which is often an after the fact complaint that you are trying to prove intentional discrimination around, you need to have complementary provisions if we're speeding up ejectment. So it is a policy decision, I think is probably so your ultimate conclusion was. And I am saying that the policy decision to me is very important to make landlord tenant law and fair housing law complementary in the case of ejectment and eviction proceeding.
So are we not able to refer? I think we're all agreed on that, but I think, are we not able to refer in our language to the fair housing laws, all of which are very supportive of the disabled community and support a lot of the concerns and address a lot of the concerns we have?
For right now, that's like saying we have great civil rights laws. Like we're in a very tenuous time for fair housing and civil rights and funding for making sure people are able to access their civil rights. So if you want to make the language that we're looking at in the landlord tenant piece reference fair housing, fine. We want to do that in other areas then too, because we should always be
but we're dealing with this bill at the moment. So if we want to make sure without incorporating all of that language into this bill, we could certainly reference the fair housing language, could we not?
So I think it depends on what you're asking to do.
Right.
As I've mentioned now a few times, I believe what Senator Ron Ensdale adapting is to change the statute to expand on the protections for individuals with a disability. It would be different than what is currently protected under the Chapter 139 that just walked through.
Right, but it is not different from what is included in fair housing. So why can't we reference all the fair housing law and use it as we work through this.
Because it doesn't reference ejection.
So what's being asked is to prohibit the landlord from being able to terminate a rental agreement because of things that the tenant is doing that give rise to being able to terminate a rental agreement.
Okay, I think on that note, let's hear from Chris Donnelly and then we can hear from Big. If we could tee up Big, but Chris, I'd like to invite you to the witness chair, please. And then, we'll hear from Big.
And can I just add, Chris, is Champlain Housing Trust Council present? Not to say like,
I think
okay,
Chris is representing Champlain Housing Trust
okay.
and as Philip.
I know, I just like, we're talking about legal questions. I'm not an attorney.
Right.
I can't remember if you're an attorney. Okay. Did your counsel talk to you about?
Chris Farley at Champlain Housing Trust.
Chris, the floor is yours.
Our counsel did not talk about this specific claim of said. I think there was something that's very similar to yours.
Yeah.
We house hundreds of people with disabilities, whether we know the disability or not. As counsel just said, people with disabilities are protected under the law. The language that I saw yesterday, and I guess being passed around, is, like I said, it's problematic. I'll explain why. By using an example. We opened up a new development last summer. Tenant moved in. She has some type of anxiety, some other type of disability. She manifests by her blowing a whistle. She blows a whistle a lot.
Okay.
Yes,
Is this
let's-
too specific of a story to tell on the record? Do you have permission? from
You know what? It's a generalized story. Let them tell it. I mean, we need
If
to hear what.
if you feel discomfort, I can stop.
I mean, because I want to ask questions that are really specific and I'm very worried about doing
Okay.
that.
So I will explain it this way then.
Yeah.
There's a tenant that moved in whose behavior disrupted the peaceful enjoyment of other people around them nonstop. We worked with her to try to resolve the issue. It's been 8 months. We have had 4 or 5 people move out of the building because of the disruption in their lives, because of the noise. The tenant is not responsive to offers of help. I got offered another one yesterday. I appreciate it.
Like other units where the,
Are there any engagement? It's been service providers, our staff, local officials, elected officials, we've tried a family have tried to engage with this person. It's been nonstop for 8 months. And that under this language here, we would not be able to move forward with a termination of her tenancy. Because this says the actions giving reason for the termination are directly related to the disability. I'm just saying that this is an example. This is one example of many that we deal with that we really work to support people to keep people housed. And it is affecting the rest of the community. And this language here would prevent us from taking any action. That's why
it wouldn't prevent you from taking any action.
we're
If
not
you-
gonna
No, this
move
language
forward
would
with a
not
termination.
allow you to evict anybody.
Well, eviction is different than taking any action.
This would not allow us to terminate the tenancy. We have taken lots of action in this case
Right.
over 8 months, and we have
Has the person refused
correct.
Yes.
the
Any help.
refused to be in a location where they're not disturbing people? And also, are they disturbing people in the middle of the night?
Mhm.
Because
Yes. Yep. Night, day, up and down the street. it's a sad case.
It's a very sad case,
Yeah.
right? I mean,
So, but Randy raised, this was when, after you left the room the other day, this is what Randy raised, that this kind of an issue of what happens when an unseen disability, particularly mental health one, is so disruptive that people can't, that it's affecting many more, that's affecting all the tenants around them. And that is not fair either. So I think we have to figure out.
regardless of whether or not it's fair, if someone has a disability, then clearly the interventions are not going to work, but that person is still a Vermonter.
Mhm.
And unless we have a continuum where they have another place to go,
But it doesn't sound like this person is even
I-
open to the notion.
we don't know that,
Well,
and
yeah,
I want
but
to
we-
stop talking about this person.
Okay, we continue to work on this. When I brought this, situation up to, advocates, the response I got back was, you guys do fine. You guys help people. You try, but smaller landlords don't. And they want to really protect some of the smaller mom and pop landlords. And I don't think having a line in statute is going to educate those tenants, those landlords. So what I would suggest is that we have a robust education program that, as though there's really very little change in the tenant law in this benefit. There's very little change left in the bill. But as we move towards getting the court study back, we have a companion piece that allows education of.
We are talking about a process of terminating a rental agreement. I need to clarify for myself, because that's a big deal, right? There's a difference between ejecting someone who isn't part of a lease agreement, who might have just shown up, and terminating a rental agreement.
There's a difference, yes. Yep. And so I believe what I heard yesterday from an advocate was that landlords need better education, especially if we're going to be contemplating
Where did you hear that?
from Brenda Siegel. Especially if we're going to be considering wholesale changes
committee?
next year. No, in a phone
Oh,
conversation.
okay, because we didn't talk about education yesterday. We talked about the procurement of it.
Right, we actually talked about this for quite a bit. I mean, we talked about it.
Oh,
Anyway, keep
That's
going.
that's my
Sorry.
suggestion is that if the issue is really, people are, as council says, people are protected under law, but the landlords don't know what the law is and they are flaunting it or not flaunting it.
Or
Just
not
don't
aware.
know, not aware.
Right.
Then let's address that. And if we're gonna be making wholesale changes or propose wholesale changes to the court process, and this is gonna be coming back next year with a study, why don't we also put hand in hand companion education piece so that landlords know their responsibilities?
so I'm sorry, but when we do landlord tenant law, we have to be extremely careful about effective dates
Mhm.
and decisions that landlords might make
Mhm.
in advance of effective dates, because something is coming.
Sure.
So this is not the right time to say, let's just study it and see what happens, because when we've talked about just cause versus non-renewal, what you have are people who get afraid of tenants who probably deserve a second chance or are not at the level of someone causing significant disturbance to the tenants around them, who might be too risky. And we pass a law that says you can evict somebody after this whole discussion. We don't put language in about protecting people with disabilities. You can affect current landlord-tenant agreements. So we can't be flippant, I would say, about the consequences of discussing landlord-tenant law in the public arena.
I don't think anyone's being flippant, Thomas.
Thank you for the example, and I get that we should move away from it. My question would be, Chris, do you see that the right, or the ability currently that you have to evict somebody has motivated changes in behaviors? And that if we were to, not using this example, but other examples where there was disruptive behavior that could be associated with a disability, that the threat, the option that you might evict them has adjusted their behaviors to the point where taking this tool away might actually complicate or compound problems.
I'm not sure the threat of termination of a lease or eviction really changes the nature of person's installation. I can't say it. It's something that people live with, and that's just back of the folks. What I'm suggesting is that if there's a path forward to actually educate landlords on their responsibilities under the current law. Under the current law, you cannot initiate a termination. Council said it. You cannot initiate a termination based on someone's disability. If landlords don't know that, then we should be telling them to protect us. And that's what I'm suggesting. And I'm not suggesting a study. I'm suggesting that there's an existing program. It just has not been funded, and it's not going to get funded this year. But they could come back, could come back and just say, this is what it's going to cost to do, and this is the type of outreach that we could do. And it would go hand in glove with the sports study.
This is the CBOEO.
Yeah, it brings us all a step forward, as opposed to putting something like this in statute, which will cause my organization to have more turnover, continued turnover, and that's public dollars that's being wasted. It's
Because somebody's blowing the whistle.
Well, try that at 2 a.m.
Okay, so
I mean, I'm sorry,
Yeah,
that's incredibly
I
disruptive.
didn't want to have to go here, but if we're talking about specific examples, I will. People often mistake why I'm so passionate about landlord-tenant law for my present situation. My father, who has since passed away, had generalized anxiety disorder and was a terrible hoarder. It affected our lives. It affected his housing situation. It affected all of the people around him. The fire marshal would have to come and say, you are going to collapse the ceiling of the people below you with all of the newspapers that you accumulate and books. And he was sometimes in subsidized housing, sometimes not in subsidized housing. But had landlords who either would work with him or would not work with him on that very difficult situation, would work with us as the family who had a difficult time, making him get rid of things and throw things away and not be a disturbance to the people around him. So this is a very sensitive topic for me about what it means to accommodate somebody before they're homeless. My sister was homeless. And I don't like to have to go here, but I'm an absolute no on the bill if we say you can terminate someone's rental agreement without giving consideration for their rights and responsibilities to when they might disclose a disability and work with their landlord on what a reasonable accommodation could look like.
I think we
I'm just going to be clear because we have 20 minutes to get through this, and I might just walk out of the room at some point.
that wouldn't help us. So that wouldn't help us come to resolution. So I think we have a whole body of fair housing law that somehow needs, without duplicating it in this statute, that we can reference in a constructive way and somehow address the disruptive behavior that affects.
I don't see language on the table in the next 20 minutes. So if it means the bill dies, then I say we start with the language that we have and work from there.
You've just heard the language that we have. Which language that we have?
We
Because
heard it
have
was
language in the
problematic,
bill.
and then we heard about someone blowing a whistle, which sounds really disruptive. F-35s are disruptive.
Yes.
A lot of things that our community members talk to us about in the middle of the night in Burlington are disruptive.
Right. But
They might have moved, frankly, next to UVM. And they want, everyone to not disturb their peace. And we work through that in ways that don't have to do with eviction or fines. Right? I mean, you're just talking to the wrong person if you're going to be talking
I think we're
about
all trying to
taking
stop.
actions about blowing a whistle when we live in an area where large housing providers have to deal with a lot of disruption that may be their fellow tenants, or it may be other neighbors, or it may be the police coming to their house.
Right.
But we have other ways that we deal with those. And people need to know their rights and responsibilities in that regard. And communities that are vulnerable, like young people and students, like people with disability, need extra protections anywhere they are afforded in the law.
And we have them in the law. And that is the question is, how can we bring all those protections that we currently have, fair housing law, into the landlord tenant law in a reference in this section and address having better education going forward? Because
Sounds like the Human Rights Commission and an attorney. would be
we're
in a
going to
better
have to
position.
talk in a second. Thomas.
How do, I don't know enough about that on the ground. How would it be qualified that the reason was related to a documented disability? Is there usually a clinician involved in these circumstances where they would establish clearly the behaviors that are associated to a disability? How is that adjudicated in practice?
Right. And how's it confirmed in a way?
I don't think there's a change to involved. People state that they have a disability.
And then,
So all they have to do is state they have a disability. They don't need a doctor to say they have one.
So defer to the human rights.
Okay, big, this is where we make.
There's a way.
Thank you. We're in bad waters.
We're fine. I mean, we're just working through this. It's okay to work through these things. Yes, big, come join.
And it's best to work through them when you're pressured for time and there's no air conditioning.
I know our best. Thank you for saying that. I'm like feeling some kind of way.
All right.
Well-
For the record, my name is Big Hartman. I'm the Executive Director and General Counsel at the State of Vermont Human Rights Commission. Thanks for letting me pop in here and weigh in. So I believe we're looking at this language right now. So what I wanted to make clear first and foremost is that this language does not represent any change to existing fair housing law. Landlord tenant law and fair housing law coexist already. I don't personally see why there would be a need to reference another section of Title IX. But I wanted to clarify some testimony that the legislative counsel provided earlier, referring you to the reasonable accommodation section of our fair housing law. When we're talking about terminating a tenancy, that's actually going to fall under section A1 of 4503, which is it's illegal to discriminate on the basis of various protected classes, including disability. And one of the terms in there is making housing unavailable. So that's how HUD and the Human Rights Commission would interpret any kind of notice of termination or an eviction, a refusal to renew a lease. That all constitutes making housing unavailable. And if we're doing that because of a disability, that even if that's only one of the reasons, that is going to violate fair housing law. And then with regards to section 5B in this language, we do feel that this adequately covers what is current law in terms of folks with disabilities who may, because of their disability, present what's called a direct threat to the health or safety of other people or themselves. And so I don't feel that this language should not change anyone's practices. This should not create some upheaval of staff to no longer deal with the situation. This is what current law is.
Good point, pass it. Why do we need it?
I think it can be helpful if you have a section of landlord tenant law that landlords are looking at to make sure that they terminate a lease legally, to spell out that this is what is the law. I think is helpful because it's a reality that landlords aren't always as familiar with fair housing law as they are with landlord tenant law. And I just want to say we do our best, separate from CBOEO, we do our best to educate landlords every single day on this law. I offer a 3-hour fair housing training that's free and virtual.
Do you do that in
6 times a
conjunction?
year.
Do you do that in conjunction with Angela Lukowski? I mean, the landlords, are landlords educated at the same time? I mean, are you doing that with Angela?
No, it's a Human Rights Commission training.
No.
So folks from the Landlords Association can sign up and attend anytime they want. And we also, sometimes when we have complaints, we find landlords that have not been educated yet. And part of our settlements often includes that they promise that they and their staff, if they have any, their property managers will all attend our training as well. But often, it's my understanding that I stole your piece of paper, sorry. it's my understanding that Angela Zajkowski is perfectly well versed on fair housing law and will
Yes, she
advise folks as needed on the implications of those laws. We won't always see eye to eye on every situation and what would be the best advice to give somebody. But you know, they also put out their own guide for landlords, and they often, I think, refer to the CBOEO guide. We have our own guide, and then we have a host of HUD resources that spell out this exact requirement.
So share with us. Thomas, do you have a question?
So just follow up on that point. So if the current landlords aren't currently aware of current laws, why do you think they'd be more aware of this law, this repeated statement of current practice?
I don't know that they would. I think, however, though, I think if you're enacting a new bill that's changing some procedures for terminating or evicting, that it's likely to be read, and it's good for that to be a reminder there. But again, I don't think that having this new language would change anything about current law as it stands under fair housing.
If you're running a business as a landlord, it's incumbent upon you to appreciate and understand law. So I think all of us who are conducting any kind of business, you have to know about the law.
We're changing the law. So
So-
where we change the law, we should be crystal clear about what our intention is.
Absolutely, and I'm sure everyone will issue all sorts of briefs on this. Cameron, would you be kind enough to comment on this language? And my concern is big. How do we address the issue that Chris and Randy have raised in committee about disruptive behavior of a person with a disability and how that is addressed?
Yeah, so I think that's where we do need to see some reasonable accommodations being made for folks with disabilities, but it doesn't mean there's nothing you can do to address it. A reasonable accommodation process envisions an interactive process where you're going to try to work with the person to see if there's a way that you can accommodate the disability while also allowing for, you know, you to do your standard property management that you need to do to
Right.
make sure that everyone doesn't move out of your building or other folks' disabilities are impacted by the manifestation of yours.
Right. So, and we also heard that when we get to court, there's a very clear understanding of what reasonable accommodation is. I guess I ask you to address reasonable accommodations trying to be made and worked on with Champlain Housing Trust and a tenant, and not being able to get to resolution with that. So would this language enable them then to begin ejectment process?
So
Which is this language you're referring to, the language.
The language
of
big has
eviction.
given.
5B that you're looking at.
Yes.
I think it could
Wait, what
create,
is the language Big has given us?
I haven't given you language. I was just referring to
Right.
language that was passed out to you.
Oh, okay.
I just printed out with the language that was on the email that you forwarded to me.
Which was the language you were looking at?
That you
Right.
forwarded to us.
Yes, which you were looking at on Friday.
But this wasn't,
I didn't
It's not
draft
a
it.
change.
Right, right.
So how does this,
So this accurately characterizes current fair housing law, how it would be applied in that type of situation. So you will need, if you're a landlord and you want to evict somebody because of the manifestation of a disability, first, we want to see that you're going to go through some interactive process to see if there's a way to reasonably accommodate them. And if there's absolutely nothing you can do, you need to still go through, like probably need to give them the warning that you would give any other tenant, right? And sometimes you can say, all right, so the whistleblowing isn't going to work. Maybe there's another way that this disability related need could be met with a different activity that's less disruptive. And if that behavior becomes so disruptive that it actually threatens the health or safety of other folks, then you still have your rights, and you have your rights under fair housing law to deal with that how you need to.
David?
So again, I don't want to dance around the issue. I really like to kind of tackle it head on. Is substance use disorder a disability? That's where we were last week. We didn't pick it up yesterday, but we talked around the edges of disability. Now we're back in disability. And that's my question. That keeps me from really embracing the language.
So disability is defined under state law. It's the same definition we use in federal law and in the Americans with Disabilities Act. And if you have a substance abuse disorder, which substantially impairs your ability to perform major life activities, then it can qualify, but that doesn't excuse people for engaging in substance abuse because they have a substance abuse disorder.
Can you define substance abuse disorder?
That is a diagnosis, a medical diagnosis. I'm an attorney. If I'm not able to provide.
Well, the question I ask is because a person uses drugs on one or more occasions, let's say on one occasion, does that mean that that person has substance abuse disorder or just decided to use drugs that day?
Yeah,
Is there a disorder that's associated with a specific level of use or amount of use, frequency of use?
that would be a great question for a medical provider, but often the folks that I'm aware of who have that diagnosis are in treatment with a doctor about that. And they may, if they are requesting a reasonable accommodation, the landlord is permitted to verify the existence of a disability and what the disability related accommodations that they may need are.
So they're already entities.
And do an interactive process to see if they can, there's a way to meet those disability
Your
related.
knowledge has that substance been tested in courts in Vermont on any issue.
Fair housing law has generally not been tested in Vermont, but we have the same statute as the federal fair housing law. And so we will draw from case law across
You
the
know whether or
country.
not substance abuse disorder has been tested in courts in Vermont on any matter.
I can't recall that for the top of my head, but I know that our statute is meant to be interpreted consistent with the Americans with Disabilities Act. And I would absolutely predict that a court would interpret substance abuse disorder as a disability, but it's going to be case specific for that particular person because it substantially impair their ability to perform major life activities. And then, it's important to note that like someone's active use of substances is not all of a sudden okay because they have substance abuse disorder. And you can take reasonable action to, prohibit crimes in your premises.
Independent of what is considered a disability, I think what we're looking at is all the tenants and what becomes fundamentally disruptive behavior and disruptive to the lives, health and safety and a good night's sleep. I mean, health and safety of other tenants is important. And it is therefore what we're looking at with this new language. If people are following along on page 2, we are considering this would be a consideration of adding a sixth under determination of a breach of rental agreement. Cam, can you comment on this language and what it would enable? And because I think I just don't, I'm not fully clear on its implication.
So, for the record, Cameron Wood, Legislative Council. So here's how I see this, and it was drafted as a 5, but you added in a new subdivision 3 in the draft yesterday. So
Right.
if this were to go into the current amendment that you have, it would probably be drafted as a subdivision 6. Few things. First, I will say, if you're going to, in the A, the first piece of this, limit its application to subsection 1, then as I mentioned yesterday, you don't need this subdivision B, and I think it could become problematic by keeping it. So I will, the next comment I'm going to make is this is also somewhat outside of my portfolio area. So I do give a lot of deference to the executive director with the expertise. I will say though, I do somewhat see this as being different than what is currently in statute. As you heard, so correct me if I'm wrong, if you're a landlord and the tenant is engaging in some sort of activity that is associated with the individual's disability, you can't terminate the rental agreement because of that activity unless you're treating that individual in the same way that you would be treating other people. So if there are facts that are indicating that you give warnings to other people, but you're not giving warnings to this individual, or you've made reasonable accommodations for others not associated with a disability, and you're not willing to give a reasonable accommodation because this individual in the circumstances, I think that would be a violation. of
Right.
The
Clearly.
current statute.
The objective is to have everybody treated fairly and equally.
What this is saying, it's new language that's going into statute. So you're signaling to the courts that this is new, it has an intended purpose. And you're saying that a landlord shall not terminate the tenancy, period. And so in this situation, I would argue it's different than the current statute because current law is you can move forward with that termination. You can make the housing unlawful as long as you're not doing it, in a discriminatory way against this individual. What this language is saying is you can't terminate rental agreements, period.
Can I
And
clarify
I
that?
think that that is different than what is in the current statute, and it would be new. One other quick comment that I will say to keep in mind, the protections, I didn't mention this, or I didn't get a chance to bring it up. The protections in the chapter 139, there's an exception for smaller housing with owner occupation. And so pull it up and share it with you if you want. This would go into the landlord tenant chapter, so it would apply to all tenants. So there is a little bit of expansive coverage there if you were to move forward.
Okay, sure.
I respectfully see it differently. I feel like we're doing a real porridge is too hot, porridge is too cold kind of thing. And I like to move away from that for a moment. In the same vein, this could also be seen as clarifying language to say, in general, the ADA and fair housing and disability protections do override, and a good landlord tenant court or whomever should be able to take that into account. Otherwise, we're actually clarifying that if someone with a disability, if their behavior is so disruptive, so criminally,
For not even criminally, I mean, just disruptive, and affecting the
yeah.
health and safety of other tenants.
well, whereas we were all able to look at B1 and B2 and say, okay, pattern of disruptive behavior is B1. That is very broad if you're talking about people with disabilities. I know we want to focus on substance use disorder, but without trying to separate that out, a lot of things that involve a protected disability can fall under patterns of disruption. What we are specifically saying is B2, that you don't have an excuse, even with a disability, if you engage in behavior that is criminal or violent. So to me, it's not saying period, you can't be evicted if you have a disability, period. It's saying the behavior level has to meet a different standard of disruption.
But-
We can go back to the whistle example or anything else. What we should not want as the housing committee are people on the street.
Obviously not. Obviously, that is not anything.
So it is a policy choice that we're saying there is a higher bar for termination of a rental agreement if you are aware of the person's disability.
If you're aware of it, we've had the back and forth about if people are
And we
aware of
wrote
it
a
or
whole new
not.
section to make sure that the tenant then knows their rights and responsibilities in making the landlord aware that it is not incumbent upon the landlord to guess at something like that. And so we are giving the court all of the tools they would need for everyone's rights and responsibilities to be met. But we are saying it is a higher bar. If the landlord learns that you have a disability, that it is a higher bar that you work with them to figure out what reasonable accommodations look like, or you cannot terminate the rental agreement. It is a straight policy choice. It is not a too hot or too cold of the porridge. And I'm like sick of explaining this because I don't know how many lawyers can say this is the policy choice that we would be making.
Right, and some of us may or may not
Exactly.
agree with the policy choice. That is what we're discussing.
But are you clear on the policy choice at this point?
I think we're clear on the policy choice. I think criminal activity and for me, health and safety of all tenants is critically important. And if there is one tenant, whether it's a mental health issue or a substance abuse issue, whatever the issue
An
is,
issue is different than a disability.
whatever the disability is, if it is affecting the health and safety of a large number of people, that is not, that is something that also should be included. And I believe that is, that could be, but you had a response to what Keisha was saying, because you,
I'm good.
okay. So I would like to, given our concerns and what you've heard from Keisha and from the rest of the committee in terms of, I would appreciate the advocates coming back to us with language that we, that would help move us forward.
You have to make a policy decision about whether you want B1 included or not. And my argument is to say that it should be a higher bar than B1 or B2 together if you are terminating a rental agreement. That it
Or
can't just be a pattern of disruption like smoking. And I like, people deal with these things all the time. A pattern of behavior of 2 or more events like smoking or blowing a whistle would be put on the same level as criminal or violent activity. And that's a policy choice that cannot be made by the advocates. You can't just mush people together and ask them to make magic happen. It is a policy choice for the chair.
No, it's not for the chair, it's for the committee.
Well,
Thank you.
you've already heard that you've lost my vote if it's between B1 or B2.
I am tired of your threatening all the time. I think that we can come to some agreement
Everyone has talked
on
about
how we
where
address.
their vote is on this bill. That is
I-
not a threat. That's what the chair is supposed to do, is count votes.
Thank you very much. I'm clear on what the chair is supposed to do. I also would like to come into some reasonable, agreement on how we move forward with disabled, tenants who may have a disability, which is, affecting a large number of other tenants, and how we can move forward, in a thoughtful way, being able to eject them when it's appropriate and all reasonable.
We're talking about terminating a rental agreement, not ejecting.
Correct. And so it is that language that I think we need for us all to be able to think.
It's our intent to pick this back up tomorrow morning.
I think we have to, because it would be great to get that, either that or we're not coming to agreement.